Hi everyone, welcome back to the Cato Solicitors Instructing, Dealing with Your Solicitor, What Makes Us Different sort of series, just to talk about solicitors and why we're different. And last week I was talking about witness statements. Well, I wasn't, I was talking about how you could go about 2/3 of the way towards drafting your own witness statement and thereby saving a lot of money. And I was going to speak today very briefly about what witness statements, what we actually use them for. Well, once we've got the witness statement, we've got a chronology. So we've got a date order of events, 1066 at the start and 2019 at the bottom. And we can see what's happened, when it's happened, and who said what to who, and what documents support that. And then we can then go about drafting your claim or your defence, and that is a document which contains what the court calls the material particulars of your story. So it's just the particulars which are legally relevant, not the whole story, just a sort of shortened summary of the story. And that's the claim or the defence, which goes to the court. After the claim and the defence, as you all know if you've been through the litigation mill, the parties normally make disclosure, so they send each other the relevant documents. And it's then that we start to complete your witness statement for submission to the judge. And this is, in my view, it's one of the most important parts of the dispute resolution process. A lot of witness statements I see, a huge percentage, I mean I don't know what percentage, but probably 70% or more, don't seem to have a lot of thought behind them. They're just sort of streams of consciousness about what happened when. What a witness statement should be doing is not just telling the story to the judge, because that's just facts. Facts are fairly cheap, aren't they? They're fairly easy, they're fairly come and go. They're like a call to the weather centre. You know, what's the weather going to be like? So, and they're soon forgotten. The most important thing about the claim and the witness statement is to actually give the court a solution. Because a judge coming to a case is facing a problem. One side saying this, the other side saying that. Maybe one side saying the law means this and the other side saying no, it really means that. Or in this situation it's uncertain. So the judge has a problem. And so the best way of handling the court is to give the court, without telling the court what to find, which is a mistake, because you'll get what's called a judicial mute reaction. So you don't want to tell the court what to find, but you want to lead the court, you want to present your claim or your defence and your witness statement in a certain way that it leads the court to a solution to the problem the court or the judge is facing. If you can do that, you'll find you're more likely, you greatly increase your chances of winning. Because unlike straight facts, which as I say, are easily forgotten, once somebody, a judge in this case, has put a lot of work into reading papers and so on, and comes to a solution, the solution sticks to them. When you have a problem in your life and you work through it and you come to a solution, the solution sticks to you and it's quite difficult to get rid of. So that, in a nutshell, is what we're trying to do with your story before you take it to court.